Okay, good morning, everyone. This is your first appearance here before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, the person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, would everyone please raise your right hand? Do you swear or affirm any statements you make during this proceeding will be the truth, the whole truth, so help you God? Okay, let's start with the lady side. Okay, you are Miss Bell.
Benson.
Ben,
I'm sorry, Your Honor. Miss Bell, step to the side for a moment. Can we circle back around to her?
yes, sir. Miss Benton, ma'am, you're charged with one count of possession of marijuana less than an ounce. The bond is going to be set at $1,500. Do you believe you can post that bond?
Yes, sir.
This is a misdemeanor charge, so your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of an attorney?
Can you repeat that for me, please?
Your preliminary hearing date is going to be set for, hold on, I'm sorry. Let me stop this glare. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sure, yes, yes, sir.
Okay, I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I said,
Okay, ma'am, you're free to go back.
Go sit in the back. Bill, step up.
Miss Bell, ma'am, you're charged with one count of robbery by sudden snatching. This is a felony offense. Bond is going to be set at $5,000. False imprisonment is also a felony offense. Bond is going to be set at $3,000. Simple battery, bond is going to be set at $3,000. That's a misdemeanor. And use or possession of drug-related objects, bond is going to be set at $1,500. That's a misdemeanor also. So that's a total bond of, let's see, $9,500. Do you believe you can post that bond?
no,
Okay. There's going to be a stay away provision on this bond to stay away from a Paula Nash. Do you understand that?
yes,
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out or your ability to post bond, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
yes, and a reduced bond.
Okay, give me 1 second. I'm going to find that you do qualify for the appointment of a lawyer. And is there any one factor that you're pointing to that you believe I should consider in reducing your bond?
My kids.
I'm sorry.
You said, do I do what? I couldn't hear you.
Is there any one factor that you are looking at for me to consider as to whether I should reduce your bond?
Yes, my children.
Is there anything else?
No,
Okay, I'm going to deny that request. Mine's going to remain the same.
Step up, go to the
that
back.
don't make no sense.
Hey, step to the back. Next
I
up.
feel my fucking nerves.
Yeah.
Don't touch me.
I'm not touching, sir, but don't touch what you do. Hey, step out and have a seat out here.
Are you Miss Charles?
Yes,
Ma'am, you've been charged with one count of disorderly conduct. Bond has been set at $1,500 by schedule, which means it was automatically set. Do you believe you can post that bond?
no,
Okay, your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to post bond, and you'll receive a new court date in the mail. Now, ma'am, you are aware that if you post this bond through a bonding company, it's going to be approximately between $150 and $200.
The problem is I'm not from here.
Okay. So, let me see. You're from, is this Missouri?
Minneapolis.
Okay, Minneapolis. Sometimes the bonding companies, you can contact family in the county where you live and make arrangements with a bonding company there so that they will come on the bond and associate a bonding company here. My understanding is that the main issue with bonding companies and posting here and posting bonds for people who live out of state is that if you were to choose to not come to court, the bonding company is in a position of either paying that money to the county or to come and get you. They would have to expend resources to come to Minnesota or Minneapolis, I'm sorry, to locate you. But if there's a local bonding company that has associated with them, that local bonding company would then take on the burden of finding you if you were to choose to not come to court. So contact your family, your friends in the county where you live, or even a bonding company if you don't want to go to your family and friends that is there. Advise them of your situation and see what they can do for you.
Is there any way you can reduce it so I can just pay it myself? Without the whole bonding company thing?
So these bonds are set by schedule, which means that a group of judges sat down and determined certain offenses are ones where we're just going to place a certain bond. So that person doesn't even have to go before a judge. They can just post a bond and bond out. Now, in situations where people live out of state, that presents a unique problem because, as you, I think, have found out, bonding companies are reluctant to sign on bonds for people who live out of state. So I'm not going to reduce it because this has been something that sat down and other judges have made the determination that this should be the bond that is set by schedule.
And how
But
much is it again?
I'm sorry,
How much is it again?
$1,500. Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Oh, yeah.
Okay, I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No.
Okay, you're free to go back.
Never see that. Step up, please. State your name.
Francis Johnson.
Ms. Johnson, oh, before I get to Ms. Johnson, I'm just going to state, you can stay there, ma'am. I'm just going to state for the record that I was informed that Imani Copeland is currently in the COVID protocol. She has a misdemeanor charge of criminal trespass. I'm going to set a bond of $3,000 for that so that she does not have to sit in jail and wait to come back out of COVID protocol. If she can post a bond, she will be free to leave. Okay, Ms. Johnson, ma'am, you're charged with one count of simple battery. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yeah.
So there's going to be a stay away provision on the bond, and I could barely make out the handwriting of the officer, but it looked as though the last name is Solomon, Saloman,
Yes,
and it
that's right.
here. Okay,
Um,
so there's going to be a stay away provision to stay away from that person. Do you understand, ma'am?
yes, I do have a question. He lives with me?
Give me 1 second. When I'm done informing you of the information, I'll let you tell me whatever you need to tell me, okay? Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. Do you plan on hiring your own attorney?
No,
Would you like for me to see if you qualify for the appointment of an attorney?
yes,
Okay. I'm going to find that you qualify. I'm going to appoint attorney to represent you. Now, what was your question, ma'am?
so that officer lives with me.
Okay.
So does that mean he has to leave or?
Well, if the alleged victim is the person that lives within that residence, as a judge, I cannot put an alleged victim out of their home. So, to the extent that that person lives with you, you would have to leave
But that's,
until, hold on, ma'am, hold on. You would have to leave until that condition is either lifted or modified.
even though I'm the homeowner?
Yes. So let me reverse the situation. Let's say that you and I are boyfriend, girlfriend, and you live with me, and I just beat you every day just because I feel like I can. And then one day you gather the courage to call the police and I get arrested because I've been beating you. Do you think then I should be able to turn around and evict you out of the home just because you reported the fact that I was beating you?
In your circumstances, no.
So, ma'am, You and this other person are adults, okay? I've been married for 19 years. The police have never come to my home. I don't know what happened. All I know is what is written here. And I have to go upon what is written here. Okay. Now, if this person is not afraid of you, that person can contact the solicitor's office and say, hey, I want that condition to be changed. And they'll look into it. And if they agree, they'll change it. But because there's such a quick turnaround between arrest and being bonded out, whatever happened yesterday, don't want that situation to flare up tonight. Okay. Any other questions, ma'am?
No.
Okay, ma'am, you're free to go back.
Next.
Is it Miss Kochinsky?
Yes, sir.
Ma'am, you're charged one count of simple battery. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from a Damon Snyder. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, I don't.
Okay, ma'am, you're free to go back. Miss Lewis?
Yes.
Ma'am, you're charged with one count of following too close. The bond is going to be set at $500. One count of hit and run, leaving the scene of an accident. Bond is going to be set at $1,500. And one count of driving a vehicle without a valid license. Bond is going to be set at $1,000. Do you believe you can post this bond of $3,000?
Yes.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back. Miss Pittman Smith, Mr. Fortas, I saw you log in.
Hey, Judge, I'm sorry. They told me 11 o'clock today.
Yes, you're fine.
Okay.
Everybody was ready to go early. I knew that your clients were on this calendar, so I was just going to hold.
Thank you, Judge. I appreciate that.
Yes. So, Ms. Pittman Smith, the same thing applies as of Monday when we appeared. Mr. Fortas, there's new charges, false report of a crime. On yesterday, Mr. Ruiz appeared before me on 2 burglary counts, and there's another charge that I can't recall at the moment. And it was indicated in the warrantless arrest affidavit that Ms. Pittman Smith and Mr. Adonis Smith allegedly told the officer that Mr. Ruiz did not live there and had not been there, I believe, for over a month, or lived there for over a month. And I recall from the hearing on Monday and from the arrest on I believe the 22nd of your clients that Mr. Ruiz in fact did live at that location. And so that is what is forming the basis of this charge. The way that it's written in the warrantless arrest affidavit, it says that both Ms. Pittman Smith and Mr. Adonis Smith alleged that Mr. Ruiz was committing the offense of burglary. And the way it is written, it could be a theft, it could be whatever. I don't know. But I've set bond for both your clients at $5,000. on this offense. I'm not seeking to revoke their bond or take any other kind of punitive action against them. But that is what forms the basis of this charge.
And that's fine, Judge. I don't know how much you want to hear on it, but, I echo the sentiments that we discussed, a couple of days ago at the bond hearing regarding the Pittmans. And just to add a little bit of background on it, from my understanding, and this will come out later at a different hearing, in a different time, in a different manner, that Mr. Ruiz assaulted, Ms. Pittman. I'm not here to say whether it happened or it didn't happen, but there's a pending TPO from my understanding. I'm not involved in that, where they're trying to gain service. But however, Mr. Ruiz had sent an email or a text message to Mr. Pittman indicating that he's left the premises and is elsewhere. That's what gave rise to the representations that were made to the court. Where his whereabouts were or are, my clients had no idea. My clients went to Home Depot to make an exchange of an item and received a call from a neighbor that Mr. Ruiz was breaking into the house. And then that's when they came back and found that some of their items were missing from the home. So that's what gave rise to the police being called and the representations being made. And that's what my clients have informed me. And it's just, I'm sure Your Honor can see it. It's just a mess that's just going to have to get sorted out at another time. But I appreciate the bond, and I appreciate you not revoking the bond. But I just wanted to give you a little bit of background because I didn't want you to think that my clients were telling me something and I was representing something to the court that was not accurate. Now, this is from my understanding, and we're delving deeper into that, and it'll shake out the way it will. But I just wanted to let you know that my clients did not have any ill will on that, and this is kind of what's been going on over a period of time, and it'll flesh out one way or the other. But I do appreciate the court's time.
Okay, and let me ask you this question. And if you don't know, you don't know. You said that the TPO had been applied for, but it was waiting for service.
That's my understanding, but I don't know. That's what I was told. Now, obviously, I haven't had an opportunity to speak with my clients, so this came through secondhand information through a family member through them. And we were talking about if they weren't able to ascertain where he is, how they're going to get him served. And I was kind of explaining the process. But, I came in this morning, found out that they were incarcerated and jumped on the call. So I haven't really been able to really get into it. And so what I have is just a general overview of what I know. So I don't want to misrepresent anything to the court. It's just what I was told, and I haven't had a chance really to delve into the matter any deeper.
Okay. And the reason I asked is because normally if someone is in custody, we don't always know at the time, but that of course is the easiest time to serve someone.
Sure.
Is when they're in custody. I will be doing ex parte TPOs next week. So I'm gonna check and see who's doing it this week, because this is something, in my opinion, it's just too many loose tentacles out there, and I believe all of this needs to get wrapped up so that the core issues can be resolved and dealt with. So, Mr. Smith, you also have a $5,000 bond, and you're in the same position as Ms. Pittman Smith. I'm not taking any adverse action against the bonds that were issued before, and I will see if Mr. Ruiz is going to have to get served. So I'm gonna check and see what the status of that ex parte petition, just so that all of these matters can get heard and resolved. Mr. Fortis, I was going to place this issue on the same calendar as the preliminary hearing before, but your clients bonded out. And so that is not going to be an issue. Sometimes the district attorney's office parcels cases out, even if it's involving the same parties and somewhat similar issues. If it's a misdemeanor, they'll send it down to the solicitor's office. So currently the date that we have for preliminary hearings is February 8th at 8:30 in the morning for misdemeanors. But of course, your clients bond out, that case will get resolved. And if you have that documentation or those communications as it relates to Mr. Ruiz, that should, well, it could, I gotta speak like a judge, it could form a complete defense to these charges.
And Judge, I'm going to meet with them this weekend once they secure a bond here. The only thing I would like to inquire about the court, and you may not know the answer, is when Mr. Ruiz was before the court, was there a stay away from the Smiths or at least the incident location, if the court will recall?
No, I did not. I
Okay.
did not place a stay away. These situations become complicated, as I'm certain you understand. I think the young lady earlier, when she was the alleged offender, but it was her house and the alleged victim was there and there's stay away. So my position is not to get deeply involved at first appearance. Preliminary hearing is something totally different where I
Understand.
can ask questions. But I did not place a stay away provision there. And if those communications exist as it relates to Mr. Ruiz, to your clients, I believe that they should print those out and keep those handy.
We're aware, Judge, and I just want to thank the court for your understanding, and they should be able to make bond. I'm going to call their family member right away, and I appreciate not revoking their bond, and I appreciate that. Thank you very much.
Okay, Ms. Pittman Smith and Mr. Smith, you're both free to go back, and Mr. Fortis, you're free to go, sir.
Thank you, Judge. Have a great weekend.
You too.
Happy New Year.
Happy New Year to you too. Ms. Pope,
Yes, sir.
ma'am, you're charged with one count of simple battery. Your bond is going to be set at $3,000. Do you believe you can post that bond?
Yes,
There's going to be a stay away provision on this bond to stay away from a Darrenese Booker. Do you understand that?
yes, sir. Even though she stayed in my house? Same.
Yeah, it's the same situation, you know. The court's hands are tied pretty much at this point as it relates to that. There's going to be a preliminary hearing date set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon you bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, ma'am. Miss Swingen.
Yes, sir.
Okay, ma'am, you're charged with one count of simple assault. Bond is going to be set at $2,000. Do you believe you can post that bond?
No, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to post a bond. There's going to be a stay away provision on this bond to stay away from a Paula Nash. Do you understand that?
Sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Miss Wooten. Ma'am, you're charged with one count of simple battery. I've set the bond at $1,500. Do you believe you can post that bond?
No,
There's going to be a stay away provision on this bond to stay away from a Journey Benton. Do you understand that?
that's my granddaughter.
I understand. Do you understand that?
Yeah, you need to tell her. Yes,
Okay.
I'm saying. So can I,
Hold on, ma'am.
okay, I'm sorry, go ahead.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, what was it that you wanted to tell me?
Oh, I was saying, well, the bond will reduce from 1,000, have to be 1,000, so I can't bond that, right?
You can go through a bonding company and pay approximately $150 to $200.
Okay.
Okay,
Mm-hmm.
is there anything else, ma'am?
Sounds
Okay,
good.
ma'am.
Thank you.
You're welcome. Free to go back.
Mhm.
That's gonna be the last female, Your Honor.
Okay, thank you for your assistance. Let's switch over to the male side.
This is Mr. Atmore, Your Honor.
Okay, Mr. Admore, sir, you're charged with one count of interference with government property. Bond's going to be set at $5,000. One count of obstructing an officer. Bond's going to be set at $2,000. And one count of financial transaction card fraud. Bond's going to be set at $5,000. So the financial transaction card fraud is a felony. The interference with government property is a felony. And obstructing an officer is a misdemeanor. That's a total bond of $12,000. You believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, do you have any questions of me?
Yes, just one question. When I got booked in, even down to getting processed in, they told me I only have one felony, which was the fraud. The other two was misdemeanors. So on your end, is that correct?
The interference with government property is listed as a felony. And the financial transaction card fraud is listed as a felony. The code statute for the interference with government property is 16724. So if it's a misdemeanor, then you have two misdemeanors and a felony.
Yes, sir.
Okay. Anything else, sir?
No, sir.
Okay, you're free to go back.
Thank you.
Mr. Blackman. Getting back to the point. Appreciate it.
Mr. Blackman, sir, you charged one count of loitering or prowling, one count of obstructing an officer. I have dismissed both of these charges. When the paperwork is received by the sheriff's department, you will be released. Mr. Cost.
Yo, keep noise down, keep noise down.
Mr. Cost, sir, you're charged with one count of criminal trespass. It's a misdemeanor. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Kelly Briggs. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you will get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
But yes, a misdemeanor, right? That's all?
Yes, sir. Yes, sir.
All right. Thank you.
Okay, you're free to go back.
Mr. Davis.
Mr. Davis, sir, you're charged with one count of family violence battery. Bond's going to be set at $5,000. One count of false imprisonment. Bond is going to be set at $5,000, and one count of cruelty to children in the third degree. Bond is going to be set at $3,000. The false imprisonment is a felony. The other two counts are misdemeanors. You're going to have a total bond set at $13,000. Do you believe you can post that bond? There's going to be a stay away provision on this bond to stay away from a Virginia Burgos. Do you understand that? Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir.
What's your question, sir?
I was trying, I don't know how to put this, but this has happened like 4 or 5 times, and she's at this court, she's using this court as a tool. She's dropped the cases. Even on this one, I wasn't even around. I'm ready to start the process of, putting a restraining order on her, eviction notices and a divorce type thing. You know what I'm saying? Because I'm tired of this. How can we stop using the courtroom as a tool to arrest me?
Are you still with Ms. Burgess, Mr. Davis?
Yes, sir. I'm done, sir. Really, this time.
That was not my question. I said, are you still with her?
Yes, sir. She's probably
So,
gonna.
Mr. Davis, if she's done this 4 or 5 times, why do you keep going back?
My son. It's an excuse, I know.
Mr. Davis, you are an adult. I can't try your case right now. I can't make determinations. So all I can do for you, sir, is to tell you that unless this is something that you like doing, maybe you need to do something differently. Okay?
Yes, sir.
Anything else?
No, sir, thank you.
You're welcome. Okay, before we get to the next person, for the record, Mr. Enrique Etanine is charged with simple battery. Bond's going to be set at $3,000. He and Miss Copeland are both in the same boat, boyfriend, girlfriend. And as I did with Miss Copeland, I'm going to do with Mr. Etanine. I'm going to set a bond of $3,000. I'm going to remove the stay away provision. I understand he's in COVID protocol. And so this will allow him to bond out if he is so desirous or willing to do so.
Yes, Your Honor.
Okay. Let's see, Mr. Flores.
So what?
Hector Flores.
Yes, sir.
Sir, you're charged with one count of following too close. Bond is going to be set at $500. One count of driving a vehicle without a license. Bond is going to be set at $1,000. One count of having a tag that is concealing the identity of the vehicle. Bond is going to be set at $500. And knowingly driving a vehicle with a suspended or canceled registration. Bond is going to be set at $500. So that's a total bond of $3,000. Do you believe you can post that bond, sir?
I don't know. Yesterday I talked with my wife. She's telling me kids outside. I don't know if she's paid my family or I don't know.
Okay. So She may have posted the bond, because this whole situation starts so early. You may have been caught in that gray area where instead of going to bonding, you're sent to court. So, the one benefit is that I can ask you the question of, do you want me to see if you qualify for the appointment of a lawyer?
Oh, yes, I have the friends, Johnny Castellera.
Okay, so you have a lawyer?
Yeah, it's a friend, long time.
Okay. Do you have any questions of me, sir?
Only I can't talk with my wife right now, I don't know, she's paid, my family paid.
The short answer is that, once you leave this proceeding, you will be allowed, to use the telephone pursuant to the sheriff's department's policies. So I can't tell you exactly when, but I know you will be allowed to use a phone.
Yes,
Okay?
yes,
Okay, sir, you're free to go back.
thank you so much.
You're welcome.
Hold, hold it.
Mr. Fulton, sir, you're charged with one count of aggravated assault. That's a felony. Bond is going to be set at $10,000. One count of battery. Bond is going to be set at $5,000. One count of misdemeanor possession of marijuana. Bond is going to be set at $1,500. And one count of driving a vehicle on a suspended license. Bond is also going to be set at $1,500. So that's a total bond of $18,000. Do you believe you can post that bond?
Yes, but why do I have a driver on suspended license when this occurred in the house?
Okay. Give me 1 second. So there's an allegation that both you and Miss Hoyle told law enforcement that you took Miss Hoyle's red Ford Focus from the apartment and returned intoxicated after multiple hours. They checked your information and said that you had a suspended license for failure to appear with a violation date of May 28th of 2008 and a suspension date of June 15, 2009. So they're basing the driving while suspended, driving on suspended license charge, apparently from statements that were allegedly made by you and Miss Hoyle.
Okay, it seemed like that should be something that could possibly get thrown out, but okay, all right.
Okay, so there's going to be a stay away provision on the bond, stay away from a Shatoya Hoyle. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived. Upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
No. No, Terry, Mark, no. Come on down.
Mr. No, sir, you're charged with one count of aggravated assault. Bond's going to be set at $20,000 and one count of battery. Bond is going to be set at $5,000. That's a total bond of $25,000. There's going to be a stay away provision on this bond to stay away from a Thomas Knowles. Do you understand that?
Yeah.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir, I do. I need,
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
no,
Okay,
yeah, yes, thank you.
okay. You're free to go back, sir.
The thing to know. Lex. Angelo. Yo, hey, come on.
What about me?
Good morning. Tell me your name, sir.
Yes, a little map.
Mr. Mallet, sir, you're charged with one count of theft by taking as a felony. Bond is going to be set at $5,000, and one count of giving false name, address, date of birth. Bond is going to be set at $1,000 for a total bond of $6,000. Do you believe you can post that bond?
I didn't take the,
That was not my question.
no, I'm saying, how did I get that one? I don't know nothing about it.
Sir, you are presumed innocent until you're found guilty, so you do not have to tell me that you are innocent. You stand here as an innocent man. Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay. All right, hold on one second. Okay, so you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, you're free to go back. Did we lose Miss? Okay, Mr. Montgomery?
Appreciate it.
How you good?
Okay. Mr. Montgomery, sir, you're charged with one count of criminal trespass, damage to property. This is being written as a misdemeanor. Bond's going to be set at $3,000. Do you believe you can post that bond?
Oh, yes, sir.
There's going to be a stay away provision to stay away from a Shahavana, a Shahavanika Johnson. Do you understand that?
Yes, sir. Can I
Hold
ask-
on. I'll let you get to your questions and the end. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, I cut you off, Mr. Montgomery. What were you going to tell me?
I was trying to ask about the stairway, cause this nigga ain't too happy about me being in here, and that's my place of residence. Like, I pay my rent, I pay the whole, all bills and all of there, like. And plus, I have my only child staying right there too, man.
Okay. Well, Miss Johnson, I believe, is the person that reported this to the police. If Miss Johnson does not like the stairway provision, first, she cannot choose not to call the police in the future. Or B, she can contact the solicitor's office and let them know of her desires, and they will look into this case. And then they'll make their own independent determination as to whether they believe this provision should stay in place or whether it should be lifted or modified.
So is there any way she can be notified of us calling the solicitor?
I'm pretty certain that there's a victim witness person that may have already reached out to her. So I'll just tell you my observations from the bench. Almost half of our cases are adults acting like children. Calling the police, and police have to come out, have to deal with refereeing disputes between adults. Sometimes the person calling the police is just angry and upset. Sometimes the person calling the police is in absolute fear. Nobody knows you or Miss Johnson. So we take the approach that the person was in complete fear until we are moved or informed otherwise. Okay, so this is being taken seriously. It's not being looked at as, oh, this is just two people and she mad and that's why she called the police. No, this is being looked at as public officials. We have a duty to protect the public. So this will get diverted over to the solicitor's office. They will look into it and they'll make their determination as to what's going to happen. Okay?
Sure. And my bond $3,000?
Yes, sir.
Yes, sir.
Okay, you're free to go back.
Richardson.
Mr. Richardson, sir, you're charged with one count of driving under the influence of alcohol to the extent that you're a less safe driver. Bond's going to be set at $5,000. One count of driving a vehicle without a valid license. Bond's going to be set at $1,000. One count of following too close. Bond is going to be set at $500. And one count of hit and run accident, leaving the scene of an accident. Bond's going to be set at $1,500. So that's a total bond of $8,000. Do you believe you can post that bond?
Excuse me? Excuse me?
Gentlemen,
Yes.
Can I understand the question?
Do you believe the bond is going to be set at $8,000? Do you believe you can post that bond?
No.
Okay. You understand you have the option of going through a bonding company where you're going to pay approximately 10 to 15% of the bond.
Yes, I would like to say something.
Okay, I'll let you get to that in 1 second. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. The date will get waived upon your ability to post a bond. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Now, what was it that you wanted to tell me?
Actually, the driver license, I have an international driver license. It was on another car. I didn't have it on me.
Okay.
The police took a picture of my picture. I have it in my phone.
Okay. Okay. So I've appointed a lawyer to represent you. You should provide that information to the lawyer. And these charges are charges that require the state. Actually, it's going to be, I believe, primarily proven as it relates to documents or documentation. So any kind of documentation that you have to support what you just told me will be sufficient. Is there anything else, sir?
Actually, an issue the police had brought me yesterday night. When they arrested me, they took my wallet, my phone, and everything. And I had about $385 cash in the wallet, and I showed them.
but I never got the wallet back. So when I reached here, I didn't know how the procedure is because the first time I've been doing this thing. So when we went to check, the money in my wallet was gone.
What happens most often, and I don't know if this happened in your situation, but if there's any kind of cash, the cash is noted, taken, deposited, and when upon bonding out, you'll receive a check for the amount that was taken out.
Well, they never did that with me. So when I reached here, and then someone told me, hey, you have to check it, you have to receive and check all your belongings. Then I went back. And then by the time we check everything, that money was gone. And I told the police that arrest me. I have my money there. It's 3 bills of $300, 3 bills of 60, 2 of 10, 1 of 5, and about 60 something cents was in my wallet.
Okay, and all I'm saying is that I understand that to be the practice, just so that it's not a situation where your wallet is placed into evidence and it has $300 in it, and then when you're getting your property back, the money is gone. So you should speak to your lawyer and check to make certain that there is a receipt for the money, the cash that was taken out of your wallet.
But it looked like that when he reached here with me, the money was gone already. So actually, it's the police that brought me here. So.
So, sir, all I can tell you is to take those steps that I've currently advised you of. I cannot go down to property and start looking for your wallet. I cannot call the officers and ask, hey, did you take 300 and some odd dollars? Okay. I'm trying to tell you the whole lay of the land. As far as I'm concerned right now, the range of possibilities is that one of those officers stole your money, or they took your money, inventoried it, and there's a receipt. Okay.
I told them I was here, so they said they were going to check on it.
Okay, let me ask you this question, and then we're going to move on. What is it that you would like for me to do as it relates to this money?
Say again, what is this?
What is it that you would like for me to do as it relates to the money that you said was taken out of your wallet?
Well, I spoke to the.
No. The question is, what do you want me to do about it?
Well, I was trying to get my money back because my money gone. Somebody took it.
I understand that. What do you want me to do about it right now? What is it that you think I have the power to do?
So, no, I'm just mentioning it to you. So, I know I lost some money. So.
And I gave you the range of possibilities, and I gave you some suggestions as what to do. And we're still talking about the money. What is it that you think I can do beyond what I've already done?
I don't know, sir. I just mentioned it, and I'm trying to get my money back, but I don't know how it works. I don't know how it works.
Okay, sir. You're free to go back.
Okay,
I've made a notation of it.
And the bond will have to talk to the company.
Yes, sir.
My court will be on 7th of February, right?
When you bond out, it was the 8th of February. When you bond out, your case will get, that court date will get changed to a new court date. Okay? Okay, sir, you're free to go back.
Mr. Riley.
Mr. Riley, sir, you're charged with 1 count of criminal trespass. I've dismissed that charge. You're also charged with 1 count of illegal parking in handicap zone. Bond is going to be set at $500 for that offense. So your total bond is going to be set at $500. You're going to have a preliminary hearing date set for February 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment? Oh, it says you refuse. You're going to hire your own lawyer?
No, sir.
You're going to represent yourself?
Yes, sir.
Okay. Do you have any questions of me?
No, sir.
All right, you're free to go back.
Pressure. Pressure. Mr. No, go down.
Let's see. Tell me your name, sir.
Roman Gresham.
Okay. Sir, you're charged with 1 count of harassing phone calls. Bond's been set at $1,000. You believe you can post that bond?
No, sir.
There's going to be a stay away provision on the bond, stay away from a Waveney Irving. Do you understand that?
No, sir, I don't.
Okay. What do you not understand about that?
We are legally married. That's my place of residence. We have 3 kids together. I just started a new job working at the airport and I missed work yesterday. I was supposed to clock in to work tonight at 10 p.m.
So it sounds like you understand the stay away provision. You just disagree with it.
I don't understand how I'm supposed to stay away from her if that's my place of residence.
Because she's the victim and you're the alleged offender.
Well, I understand that, Your Honor, but it's gonna get resolved anyway because it's only a verbal, altercation. We never got physical. We don't do this on a regular basis. But I'm not even from the state. I've been here for about a month. I just started a good job at the airport. We about to move from an apartment into a house. So that's why I can't make the bond, but I understand.
Okay. So if you were to violate this condition, you could get charged with aggravated stalking and be in jail until your trial, which would certainly lead to your losing your job. Do you understand that?
Yes, but why does the no contact order have to be put? I mean, she's not pressing any charges. We're not arguing no more about it. Like, that's where my daughter stayed. That's where I live at. I don't have nowhere to go. That's my home. I'm on the lease and everything. How am I supposed to stay away from my wife?
Okay, so this is the wife is the mother of your child.
Yes, sir.
The allegation is that you texted her 8 times, threatening to shoot both yo MFers.
Her and her friend, her and her home. Yes, her and her girlfriend were like.
So, Mr. Sir, if you didn't know me and you are in the position of deciding whether I get to go back around my wife or not, and the only information you have is that I told my wife I'm going to shoot, I texted my wife 8 times, I'm going to shoot both you MFers. Do you think it is reasonable for you to say, oh yeah, I don't know you, but go back? Ain't that gonna happen?
I don't get the question because I know my wife. Like,
yeah, I don't know you. Sir, this is real simple. Don't send text messages threatening to shoot anybody, and you won't be in jail. You won't have a stay away provision placed on you, and you'll be going to work tomorrow. But if you decide to send those text messages and the police get involved, we have a responsibility as a judicial system for public safety. We don't know you. We can't do a blood test to determine whether you're going to go and shoot and kill somebody tonight or not. We don't. So we got to take bright line precautionary measures. The way that you keep yourself out of this is don't send threatening text messages. Don't threaten people, whether you believe it, whether you are true about it, all of that stuff. So don't come to me asking me to place you in a position, as they would say, the fox guarding the hen house. I don't know you. The solicitor's office, they will do an investigation. They will determine whether it is safe for the two of you to be together. But I'll tell you this, whatever relationship you have, the fact that you're sitting here in jail, maybe you need to reconsider the relationship. That's all I'm saying.
This wasn't, I wasn't supposed to be there. Like,
Okay. Your preliminary hearing day is going to be set for February 8th at 8:30 in the morning. Would you like me to see if you qualify for the appointment of a lawyer?
sure, why not? I ain't going nowhere.
All right. You do
Bullshit ass
qualify.
Yo, you're not done yet.
fucking stupid ass shit, man. What you up to?
So, sir, that comment that you just made right there is sufficient to have you held in contempt of court, which could be up to 30 days in custody
I'm already here. I'm already locked up in jail as it is, man.
because of your actions, which by what you've displayed so far, I think I'm going to see you a lot. So we should get to know each other.
There you go.
We
I
should,
don't get
we
clowned.
should,
I'm a family man, okay? I'm
we
here
should, we
to
should,
argue
we
with my
should,
wife. I'm
we
here
should
to
get,
argue with my wife, so you ain't gonna see me again, Your Honor.
we should get to know each other because I don't believe you can control yourself.
There you go.
John, you done with him?
Yeah,
I'm
you go.
done.
Step up, step up.
Thank you.
Victor Smith. Yes, sir. Take your time.
Mr. Smith, sir, you're charged with 1 count of aggravated assault with a deadly weapon, 4 counts of violation of Georgia Controlled Substance Act. Those are all felonies. I've denied bond at this point on those felonies. You have a misdemeanor charge of possession of marijuana less than an ounce. There's a $1,500 bond set. There's going to be a stay away provision on the bond to stay away from a Sawana Randolph. Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. You're going to have a bond hearing date set for February 11th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I don't know the reason, but I was wondering what is the reason why you can't set a bond. I know I got the probation, right? Oh, go ahead. I'm sorry, sir. I mean, cut you off.
No, go ahead.
I said, I know I got the probation violation, but I'm just trying to handle some things because I'm trying to go to school as well. And I'm just wondering what's the weight on bond as far as setting the bond.
So this can be something negotiated between your lawyer and the district attorney where they can consent to a bond. It happens. I get them all, not all the time, but I get them on a pretty frequent basis where there have been agreements reached as it relates to bond. and I don't get between the parties. So if your lawyer and the prosecutor agree to a bond, I sign off on it.
Yes, sir. I understand.
Okay. Anything else?
No, sir. Thank you, sir, for your time.
You're welcome. Free to go back.
All right, thank you, sir.
Okay.
Smith. Oh. Hold up.
You are John Joseph Smith?
Yeah.
So you're charged one count of criminal trespass. Bond is going to be set at $1,000. Do you believe you can post that bond?
$1,000.
Yes. It's just basically $100, between $100, $200. There's going to be a preliminary hearing date set for February 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yeah, I want to ask you, am I gonna be getting out pretty soon?
Yes, you're going to have to go through, well, you can either pay the entire $1,000 amount, or you can go through a bonding company and pay between $100 and $200. The paperwork will come across today. So the jail will probably, Sheriff's Department probably get that paperwork by 2 o'clock. Okay?
2 o'clock in the morning?
No, this afternoon. I do the paperwork. So as soon as I'm done here, I start on the paperwork, and it generally takes me about 2 hours to complete after the hearing.
All right.
Okay, you're free to go back, sir.
Take a seat, Mr. Smith. Just take a seat. Sebastian, yeah. Sebastian. Oh, no, go to the door. Yeah.
Mr. Smith, sir, you're charged with one count of entering an automobile. Bond is going to be set at $6,000. Do you believe you can post that bond? This is a felony offense, so you're going to have a preliminary hearing date set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Sorry, sir.
What did you say?
Do you want me to see if you qualify for the
I don't even
appointment?
know what you're talking about. What's going on? What was the charge?
I have no idea what he said.
I don't know what you said, the charge or anything.
Okay, let me start over. You're
Please.
charged with one count of entering an automobile. Bond is set at $6,000.
Okay.
Your preliminary hearing date is February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail.
Okay.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you did not fill out the form.
No, I don't need no lawyer. I don't know nothing about no. I didn't do it, but I wouldn't even do it. It's not even my, I wasn't supposed to be arrested. This ain't got nothing, I wasn't even in the plan. This is the folks can't pick up my house. I don't know nothing about these folks got going on. And I'm sick of this, like third time this shit happened. I'm tired of it. I ain't signed up to do shit they got going on. This not nothing with me.
Okay, is there anything else, Mr. Smith?
Are y'all here? This is a lie.
Mr. Smith.
I'm saying this is the first time they did it.
No.
What's the so how can I get out of jail? Like what's the thing like? How can I get pay the bond? Well, not pay the bond, but get the bond. But I don't know. You got $6,000. Like this is a lot. Hey, leave your mask off.
Mr. Snyder.
Did the judge dismiss it? Did the judge dismiss it? Answer the question. This is some bullshit. I didn't remember they said that. Hey, listen. First of all, put a mask on. Put a mask on.
Your Honor, you done, are you done with them?
Okay.
Yes,
Be quiet.
yes, I'm done with him, but the allegation, just so he knows, is that an officer allegedly observed him going to vehicle at the airport, pulling on door handles. And the officer allegedly observed him open the door handle of a Jeep and caught him going through the glove box. So that's why he's here.
Okay, he heard everything.
Okay.
All right, next up, Mr. Snyder. All right, go, yeah.
Mr. Snyder, sir, you're charged with one count of simple battery, bond is set at $3,000, one count of simple assault, bond is set at $3,000, one count of cruelty to children in the third degree, bond is set at $3,000, and one count of obstructing an officer, bond is set at $2,000. So that's going to be a total bond of $11,000. Do you believe you can post that bond?
Say that again, please, sir.
It's a total bond of $11,000. Do you believe you can post that bond?
I want to hear my charges one more time.
Okay. Simple battery, simple assault, cruelty to children in the third degree, and obstructing an officer.
How would I have simple battery and simple assault?
Okay.
I thought that was the same charge.
Oh, hold on. They're not the same. Simple battery is was touching someone without leaving a mark in an offensive manner. Simple assault is you don't have to touch the person. You just have to place them in reasonable fear of receiving an injury. So in your case, the simple battery is alleged to have occurred by you allegedly grabbing the hair of Miss Koczynski and pulling her by her hair. And it says that it was observed on security video footage. Simple assault is by placing Miss Koczynski in reasonable fear of bodily harm. It says after pulling the victim's hair, you allegedly placed her in fear that you were going to hit her, that you committed the offense of cruelty to children in third degree by grabbing Miss Koczynski in the presence of a juvenile, last name McLean, by the shirt, then pushing her against the wall multiple times. Says that you and the alleged victim previously resided together and that you were in a relationship. Does that make sense to you now, sir?
Yes, sir, it does.
Okay. So your preliminary, there's going to be a stay away provision on the bond, a stay away from a Lashari Koczynski. Do you understand that?
Yes, sir. I had like two questions. What would that range out to be? What would the estimate be when I do place bond?
Approximately between probably $1,000 and $1,400.
Okay. Is those misdemeanors?
Yes, sir.
Okay. And I wanted to ask one more thing. This is how much time do you think all that will hold all together?
I have no idea. For each offense, the penalty range goes from probation to a year in jail. These offenses can be run concurrently or consecutively, which means the maximum possible time is 4 years.
Yeah, if they ran consecutive.
Right.
Okay.
Right. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any other questions for me, sir? Okay, you're free to go back.
Thank
Mr. Spain, sir, you're charged with robbery by snatching, sudden snatching. That's felony, bond is set at $5,000, sorry. Simple battery, bond is set at $5,000, and financial transaction card fraud, which is a felony also, bond set at $5,000. It's a total bond of $15,000. You believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond, stay away from a Paula Nash. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Never at all, sir.
Okay, you're free to go back.
Stewart.
Ms. Stewart, sir, you charge one count of failure to have your headlights on. Bond is going to be set at $500. One count of an open container violation. Bond is also going to be set at $500. And one count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. You're going to have a total bond set at $2,500. You believe you can post that bond?
I hope so.
Okay.
You make these phone calls.
Your preliminary hearing date is going to be set for February 8th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, you said something, Mr. Stewart. I didn't catch all of it. Was that a question?
Well, I'm hoping I can get in touch with my family. I haven't been able to make phone calls or anything. I do have one question about the driving without the headlights. Is it possible, or that could be? I mean, I wasn't on the road 30 seconds. I just forgot to turn the headlights on. It wasn't like I drove a mile or two. I hit the road and all of a sudden lights were on me, police lights were on me.
My understanding is that there's not a time requirement as it relates to how long you're allegedly driving without your headlights on.
Right.
Okay. Anything else, sir?
I understand. Nothing else. Sir.
Okay, you're free to go back.
All right, thank you.
You're welcome.
Sorry, can you give me the total of that bond again, please? I'm sorry.
$2,500.
All right, thank you. We don't get all that. To the Waives. This taxi.
Afternoon, y'all.
Good afternoon, sir. You're charged with one count of aggravated assault by strangulation. I've set the bond at $10,000. And one count of criminal trespass. I've set the bond at $3,000. Aggravated assault by strangulation is a felony offense. There's going to be a total bond of $13,000. You believe you can post that bond?
Yes.
There's going to be a stay away provision on the bond, stay away from a Jelen weeks. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for February 9th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, because I think I have one on standby, but I may not.
Are you currently working, Mr. Weeks?
Yes.
About how much do you make per hour?
I don't get paid per the hour, I get paid per day.
Okay. Give me an average of what you think you make in a month.
In a month, 4,000.
Okay. You're on the edge, but I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. If you so desire to hire your own lawyer, just notify the lawyer from the public defender's office, and they will, so they can remove themselves from the case.
Okay. Okay.
Any other questions, sir?
Yes, sir. Could I get a reduced bond by chance?
No, no, I'm not gonna reduce the bond in this case.
All right, and how much is the total bond again?
It is set at $13,000.
All right, thank you.
You're welcome.
That was Mr. Allen, he's a fugitive, Your Honor.
Okay. Mr. Allen, sir, you have the same rights and privileges as the other people that were here on this calendar this morning, but you're in sort of a slightly different posture. You are charged as a fugitive from justice. And what that simply means is that there is a warrant for your arrest out of the state of Illinois. And it says that it's condition release violation, which I'm assuming they're alleging that you violated some condition of your release. They've indicated that they want to extradite you back to Illinois to face these charges. You have a right to challenge that process, and you can demand a hearing to determine whether you are the person named in the warrant and whether this warrant actually reflects a valid charge. If you were to elect that option sometime between now and 90 days from now, there will be a hearing to determine those conditions. If the judge at that point determines that those conditions are valid, then your case, they'll sign off on the extradition paperwork, and Illinois will be notified that they have 30 days to come and pick you up. If they don't come and pick you up at the end of that 30-day period, they can request another 30 days for a total of 60 days for that process to take place. On the other end, if you believe you are the person named in the warrant and that you believe that this warrant does reflect charges that are valid, you can elect to waive your hearing. If you were to waive the hearing, you'd sign the waiver paperwork today. I would sign the paperwork today, and that 30 to 60-day window that I referenced earlier would begin running today. Do you have a lawyer representing you on these charges or these allegations up in Illinois?
Rather not here in Georgia. Can I ask a question?
Yes, sir.
So I actually signed these waivers, and I'm not sure I want a better understanding of this. I signed it in another state, so I'm actually out on bond and have to go to court for this extradition. I'm only here in Georgia for my son's health condition. I got pulled over, and my lawyer did tell me to keep a paper, but I actually forgot the paper. Actually, back. Yeah, he told me to keep a paper there. And I actually just misplaced the paper and bring it with me outside to where I was headed. I got pulled over and they told me that I had a warrant, but I was also aware of it. And I told them that I have a paper that I'm out and I have to go to court on this extradition as well in another state. And I don't know, I want to better understand, I don't know if I can sign in 2 states or how that goes, but I do have court on this extradition in the following weeks from where I'm from.
So the short answer is yes, you can sign. If you were to contact your lawyer,
which I haven't had a chance to do yet either.
Right. What I was going to say is this. I actually had a person in a similar situation as yours yesterday, that they were wanted out of Texas. And there was a person last week that was wanted out of California. And both of them were able to get their lawyers in Texas and in Illinois to address the issue. And both of them were released within a day.
Okay.
So if you can get in contact with your lawyer in Illinois, have your lawyer to send the appropriate paperwork that reflects that this warrant, and I'll give you the warrant number. You have something to write with?
Yes, I do. Yeah.
No, don't write on there.
Yeah, a lot of them, right?
No, we,
Right on the buckle.
All right. Yeah. I'm ready for it, Your Honor.
Okay, it is W 541 689 275.
Okay, and this is the warrant, correct? The warrant number?
That's the warrant number that's listed in the paperwork that I have. If your lawyer were able to get the information, the documentation to show that this has either been lifted or that there, hold on, calm down for a second. Whether it's been lifted, that they're not gonna seek to extradite you, or that a bond has been paid such that you can be released. They provide that information to the sheriff's department and they will release you. As I indicated before, we have no interest in your case.
Thank you, Your Honor. So,
You're welcome. Anything else, sir?
yeah, just to make things clear, should I talk to my attorney first before signing this waiver here?
If you feel that it's necessary, now the waiver is not an indication of guilt.
Okay,
The waiver simply says, I'm not gonna fight
okay,
this. You can come get me.
yes,
And in some instances, a person signing the waiver actually strengthens the hand of the lawyer in the other state, because Illinois knows that they're on the clock to have to either come and get you or you're going to be released.
okay,
And with the COVID stuff that's going on now, what I am just observing is that most jurisdictions they're not willing to put their people on the road to travel if there's another way. So it just simply says violation of bond condition or violation of conditions of release. So if you were charged with murder, armed robbery, aggravated assault, I'm certain that they will expend the money to come get you. But for some lower level felonies or really lower level felonies, I don't see a desire by and large to put people on the road.
thank you, Your Honor.
Okay. All right, sir. Once you sign that, if that's your desire, you'll be free to go back.
That's all 7 copies right there.
All of them?
Yes, sir. You can just take a seat.
Thank you, Your Honor.